Hello, I'm Claudio Lombardi, professor at KIMAP University, and I'm very happy to introduce tonight's guest, Masako Wakui. Welcome, Masako, and thank you for taking the time to speak with me today. So, Masako is a professor of law at Kyoto University. She previously taught at universities of Osaka City and Rikyo. Her research focuses on Japanese competition law and policy, but her research interests span from economic law, merger regulation, consumer protection, all the way to social law. And it's exactly in this direction that we will steer our conversation today, as we will focus on what happens when workers unionize, mostly adopting the perspective of competition laws in Japan. Masako has very recently written a brilliant paper on collective agreements and competition law in Japan in the new economy. Now, Masako, the job market has changed dramatically in the last 2 decades. The digital economy has changed the governance structure of the firm, and with it also the nature of the employment relationship. Of particular interest here are the work arrangements such as cloud-based freelance work and gig work, where the worker is usually categorized as self-employed. Here we often have stark power imbalances between the gig workers or the new self-employed workers and the employers. In your research, you document a number of unfair labor practices in the traditional employment relations and in the new non-standard form of work. What are these practices and how do they relate to competition law? Can you tell us a bit about that?
Yes. So my turn, do you think?
Yeah. Thank
you for having me.
It's all yours.
Thank you for having me. It's such an honor. And thank you very much for such a kind introduction of myself. Yes, I don't know. Right. So what is happening in the labor sector? Well, perhaps I should first clarify that in Japan, I haven't seen the rise of gig economy to the large scale yet, in my feeling. So I still do not know. Although I feel that I'm seeing more Uber Eats deliverers on streets since the coronavirus outbreak. And even before the coronavirus, the Japanese government and labor law researchers are already examining its impact and any necessary reform. Then what is happening or what are the problems? Simply put, typical bargaining power issues are rising. At each transaction level, the gig workers was typical workers, self-employed workers experience abrupt cancellation, termination of contract, retrospective changes to contract terms, low payments, misrepresentation and other misleading practices, and compulsion to purchase to unrelated goods and services. When it comes to the gig worker, these practices can be done or prompted both by customers and matching platform as well. Then perhaps, can I share the
Absolutely, yeah.
Yes. Yeah. Am I doing right from the beginning?
Yes, I can see.
Yeah. Yeah. Are you seeing the screen? Slide?
Yeah, I can see your screen. Now everything. You can share your from the beginning.
Oh, okay. Right. So
perfect.
These are like bargaining power or imbalance of bargaining power. It's like more related to the might sounds be related more to more about the fairness issue, but these are also related to the competition. First, the issues may be the result of the anti-competitive practices such as no poaching agreement or non-competes or mergers. Then clearly the competition law has the role to play to prevent these practices from taking place. Then second, one may consider that these activities relate to the process of competition or the norm, like notion that competition are based on merits. Then misleading practices or the comparison of coercive measures, employment of coercive measures such as the force them to buy something can be seen to violate such norm. Then furthermore, if an enterprise abuses its counterparties, for example, by hiring and paying the self-employed workers far below the statutory minimum wages level, then if such practices gives that enterprise competitive advantages relative to its rivals, one may think that it's kind of that situation is unfair from the point of the competition or the competition on the merits. Last thing is that obviously this and the fairness can relate to the distributive justice. Simply put, fair prices or fair bargain. Then how these relate to competition, I think it would depend on how we define the competition law. Let me try. How can I? Yeah, here. Every jurisdiction takes different approaches regarding the coverage of the competition law and what the competition authority should do. Better or not, or fortunately, in Japan, all of these, what I just described, are actually covered by competition law, also known as Antimonopoly law, and Japan Fair Trade Commission, competition authority, deal with all of them. And also JFTC, furthermore, the JFTC also deal with the supplemental law, the Subcontract Act too. Yeah, so going back to your original question, it's such a formalistic answer. There is a fairness issue, and there's issues, problems, and they are, in Japan, they are maybe that's all of them, maybe the competition law issues. Yeah.
Okay, that's really interesting. So what you say is that there might be competition law issues that blur the boundaries between unfair practices, contra law, and competition law, but here we have to add an additional layer. According to your research, I can see that Japanese workers have specific constitutional rights to unionize and organize themselves, and, for example, go on strike. So here, do self-employed workers benefit from the same protection as employees?
Yeah. Yes, yes, you are right. Thank you for reading my paper. The Constitution of Japan guarantees workers the right to associate and to go on strike. To add to your the question that the fundamental rights and the unionists and strikers are exempted also from civil and criminal liabilities, and clearly their activities do not violate competition law too. Then answering to your question, whether self-employed workers benefit from such protection depends. Yeah, Japanese labor law uses multi-factor tests when deciding whether a particular person is deemed to be a worker. The factors to be considered include whether she or he has discretion regarding when and where and how they work, and whether they are integrated into the employer's business organization. Well, interestingly, the factors include whether there is no evident sign that person is an enterprise, meaning this implies that even where they are operating a business, or if there is some sign of showing that the person is an enterprise, if it's not evident, then that like for example, well, simply put, running the business on their own or being a sole trader not always mean that they are unable to access protection. So it's a bit complicated situation, and self-employed workers are examined on the case-by-case basis, taking into these factors. So to give you some concrete example, truck owners, freelancers, franchisees who run convenience store, all of them may or may not be worker. They are examined case-by-case basis. And where once they are deemed to be worker, they benefit from the same protection as typical employees. So that is a partly my question. But before we move on to the next question, let me add one remark. Now, what I just explained is about legal status of the self-employed worker or state of protection under the law, whether they can indeed get engaged in union activities and or whether their activities are effective are different matter. Trade unions in Japan are free to set their policy in relation to the membership. In Japan, trade unions are predominantly enterprise union, and they are very slow to accept atypical workers. And also what the self-employed workers need tend to be different from the typical employees who are the member of the typical or the trade unions in Japan. So even if the self-employed workers are eligible for the protection, in fact, they may find it hard to get engaged in union activities. So that is the situation. Sorry.
Okay, that's so here I can recall a number of examples also from my experience as a EU lawyer, but also a non-EU lawyer, a Eurasian lawyer, where in particular in the EU, we have the definition of undertaking as well as our employee, which is not very, which doesn't really clearly apply to these new categories of workers and employers. So also there we are trying to find new definitions, new names that not always though fit the current regulation. So I can see that some sort of uncertainty exists also in Japan, which actually makes us feel less lonely in this endeavor. Well, what I was wondering is that in your paper, you also posit that market definition tools relying on market shares might be ill-suited to deal with this union's market power and market definition. So can you tell us a little bit more about that?
Paper again. Yes, in that paper, I have tried to, that paper, I think it's going to be available for the listener.
Yeah.
It's online now. It's on my website. So if you are interested, then you can read it. Thank you for reading. So I have tried to analyze what competition effect the trade unions can have. Then I wrote, as I said, that market share is not decisive or ill-suited in determining how influential the unions are. In my view, the more important factors are whether the union can mobilize the members to go on strike, as well as the political influence that the union can exert. I'm not the first to think so. American labor law and economics scholar have been focusing on strikes for decades. Please refer to my paper for details. So what I just said may be specific to the jurisdiction, particularly the Japanese situation and European situation that may be totally different. I think it's very different, in fact. In Japan, as I said, the trade union does not fix the price. it does not limit the output, total output either. And very importantly, most trade unions in Japan are enterprise unions. And union members are employed by employees, employed by a particular employer. So this means that the members have already made a decision to work for the employer according to their employment contract. And then trade unions do not determine how long the members should work either. So trade union fix or control neither the price and neither output in Japan. Limiting output is simply not the way that the trade union work in Japan. Then when we look like the 100% market share in analyzing the competitive whether or not, in order to tell if the particular company has the market share or not, then if you find the 100 market share, we would think that company has the monopoly power, and then our presumption is that the company is in the position to set its limit output. Set its output. And then by reducing output in the market, the company can raise the price over the competition level. And on the other hand, when we say the market is concentrated and collusion is likely, in that case too, our assumption is that each company is a single entity and in the position to control the output. And trade unions are different in that regard. They do not control the output and the price, so they do not control these parameters. So that makes the market share meaningless, I think. If you can give you an example, me becoming an Ascora member won't mean that I limit my output or the number of articles that I'm going to write per year in accordance with the agreement that I make with the other Ascora members. Ascora will never set the limit, and I would have to comply with it. We, of course, do not want to engage in price fixing. In a similar way, the trade unions in Japan do not control these parameters. Then instead, right, this should have been there. Right, and instead, the trade unions can go on strike, and unions are different from business enterprises in that regard. Strikes means that the workers violate the employment contract, and the Japanese constitution allows them to do so. A strike can cause damage to the employer, and in order to limit the scale of damage, the employer may have to compromise, may have to agree with the request from the trade union. This is the way how the trade union managed to raise wages and or improve working conditions. So this is the companies might do boycott, but it's, I think, rare. And in contrast, the strike on strike is a primary way for the unions to have the change the wages or improve the working conditions. So that is the method to measure their power or influence should be different. That is the basic insight or basic start point of that article. But having said that, this is only what I just said about the union and the strike. It was only the theoretical possibility, though. It is possible that the employer holds their stance and do not give in. If the employer can substitute the strikers with non-member employees, or if they can hire temporarily some other substitution personnel, the employers will find it easy to counter the strike. Then strikers will only lose part of their earnings that they have earned if they had not gone on strike. And in that regard, market share actually may be relevant to some extent. Because the market share may give you some insight as to how easily the employer can substitute the strikers. However, this will depend on how we calculate the market share. And generally speaking, I think it's unlikely to be a good indicator anyway, particularly in Japan. I would argue that the membership rate within an enterprise is more relevant in this regard, not the market share. Then even the membership rate within a particular enterprise too may not be telling, because a high membership rate does not always translate to more frequent, more effective strike action. Again, if I could use the same analogy, the high membership rate of the particular academic society does not make that society, does not always make that society itself powerful. That society may hold a conference once a year. Then the members may not expect more than that from that society. So a trade union in Japan is the same. We need to know what the trade unions actually do on case-by-case basis. So that is the, I'm talking too much, but one of the reasons that why I thought the market share is not very good. And another reason is the efficiency enhancing effect of trade unions or the variety of activities that trade unions are engaged in. In that paper, I try to explain these like variety of activities that trade unions do. So please have a look at my paper if you are interested in. But perhaps I would like to defer in this interview. I'd like to these two books. One is the Freeman and Madoff, What Do Unions Do, published in 1984, and the following follow-up study done in 2006 by Bennett and Kaufman, What Do Unions Do, a 20-year perspective. So including this, literature after literature in the field of labor economics tells us that trade union is not just about improving the working condition, not about raising wages. It's more like the monopoly phase of voice, like monopoly versus voice. This is what I wrote. Like monopoly implies that the union is acting in order to raise their wages, the members' wages, or the voice is like acting or functioning as the way to give input a contract or a negotiation process, like employees' voice, delivering it in an effective way to make the contract or working condition more efficiently. And if you look closer, there are more than one, more than two phases, in fact. Here, even more phases. The trade unions enable efficient bargaining or working conditions, raising investment and working employment terms, enhance the skills and knowledge necessary to bargain and conclude employment contract in an effective and more efficient manner. And they also address the fear factor that then ensure that employment contracts are honored or complied with by the employers. Furthermore, it provides a channel for managers to communicate. So this is can be like from the employer side to employees to communicate with the workers side. And it's also, this is very important, particularly in Japanese context, it can enhance relation-specific investment by like making sure that after the employees' relation-specific investment, they are not abused the locked-in situation. So yeah, and the last thing is that they also gave the helpful, valuable input to the regulation and legislative process too. So then the economist, partly labor law professors, I think in particular in the United States, are still discussing and trying to measure the union's effect. From Japan, I can say two things. First, a survey in Japan shows that even employers think, particularly the managers of the big companies, think that the trade unions important for the better communication, for the efficiency. And second, trade union in Japan rarely go on strike in Japan, so does not show the face of monopoly that much. So then our question is that in that case, what do the Japanese unions do? So I think that still, if you look at the Japanese way that Japanese trade union act, well, my impression at least is that the trade union is not, the function of the trade union is not limited to acting like cartel or a group or organizations to coerce the employers to raise wages and so on. So these are, again, modes of activities that the unions are regularly engaged in, and what the business do not do, like on the day-to-day basis. The business may do lobbying activity, but if we measure, well, first, antitrust scholars or authorities do not measure their political influence like as a routine. They might do, but it's not their practice. When we need to measure political influence or the impact of the businesses' lobbying activities, perhaps we would not see them. We will not define the relevant market and the calculated market share. To me, like defining the relevant market and then the calculated market share is not very effective way to do it. So sorry for my very long explanation. So that is the reason why I thought the market share is not that very good.
Right. Okay. So just to very quickly sum up a couple of points and go to the next question. So you clearly stated that they are trade unions are not cartels and are not monopolies. However, they may have an important function, especially through the bargaining power, where they may even the positions, the bargaining positions between the workers and the employers on one side. Among the other things, for example, avoiding hold-up situations and a number of other abusive practices. However, here, with the power of trade unions waning, what are your proposed alternative solutions? So is there something that can replace the trade unions and possibly have the same countervailing power that they've had for many decades now? And what do you think is the role of competition law, if any, in these labor relations?
Yes, thank you. My simple question is that there is no alternative. I haven't found any alternative solution, although there might be there will be the supplement solution that supplement to the weak trade union. Well, let me begin. I have not given up on trade union just yet. In fact, I'm still hopeful. The poll in Japan, the poll suggests that the Japanese citizens, including the younger generations and employers, tend to see the unions as important. Then why they do not join the trade unions? I don't know. Perhaps the free riding issues, but anyway. Then, and as I said, so far as I'm concerned, there is no alternative to trade union. There are the independent organizations that protect the interests of workers. And actually, the COVID-19 pandemic demonstrates the importance of their function, I think. So it has been the trade unions that have been requested that employees that take measures to protect drivers, deliverers, hairstylists from getting infected with COVID-19. And they are acting upon abrupt redundancy as well. They're pretty much very impressive for me, how they work and how effective they are, how quick. So the trade unions in general are first to grasp, understand and comprehend the problems that are specific to the workplace, and they are in a position to tailor the solution by taking into account the specific nature of the workplace. So the trade unions activities benefit not only the employees, but also, actually it might also benefit the manager side or long-term growth, then in the end, ultimately, also the general public. And policy making process too, unions provide helpful input. So simply put, my answer is there is no alternative. But having said that, as I said, trade unions in Japan are indeed very weak. They are trying hard, but they may be important at the time of pandemic. But under normal circumstances, their influence is hardly felt. Professor of labor economics in Japan once described that trade unions in Japan are dead. I'm aware that several labor law professors, as well as the unionists themselves in Japan, admit that the trade unions are powerless. And then I agree. If you look at the statistics, like number of the strike action, as I said, I think the strike is very important for the trade union to be to have influence ever, even if their political influence is important, but their political influence is also closely connected to relate to their strike action. Then if you look at this statistics, the strike number of the strike is very small in Japan. In the OECD document, it's described at 0. So there is also no political party such as Labor Party that has a close and stable relationship with the union either. So yeah, and as I first indicated, like when we talked about the multi-factor test, and the category of workers, like gig workers and self-employed workers, cannot act as a member of the trade union to begin with. So there should be some supplemental measures, solution. Then, as I first discussed, this is what I understand, and I understand that the problem is related to the imbalance of bargaining power. In the end, I want to see these problems are addressed in some way or the other. Then, so how it can happen, how we can address this issue, and what the competition law can do. The workers, either typical employees or self-employed workers or gig workers, can unite further. It would be great if I can see we can strengthen the policymaker come up with the measures that to strengthen or restore the trade unions. Partly or largely it's up to the trade unions as well as the workers, but it would be great if the more unions grant membership to gig workers and other types of the self-employed workers, and if these workers start joining the trade union or forming new ones, so long as the law permits. Just notice that remind you that the law relevant to this is not only the competition law, civil law and criminal law have to exempt them from their the criminal and the civil liabilities as well for the union to flourish. But focusing competition law about this, to further unionization or forming some kind of association, competition law in Japan can do several things. In fact, I think, yes. The first, it can, or in my opinion, it should clarify and guarantee that the horizontal activities will not be prosecuted on the charge of competition law violation. About this, we should first, in order to, about this point, the first point, I think that we should first realize that as you said, trade union is not the monopoly, is not the cartel, and it has the efficiency enhancing. It can have the very good impact on the economy and society as a whole. This, well, about, not very clear, I'm sorry. Well, about this, about the first point, under the Japanese legal regime, it's already clear, or should be clear, that Japanese competition law never applies to the activities of trade union, as I first said, because it's fundamental rights. And the JFTC has already made it clear in this report that the trade union's activities do not does not violate the competition law already. So there is not much for the JFTC should do when it comes to the typical employees. The remaining issue is about atypical, like gig workers and self-employed workers and freelancers and athletes and freelancers, franchises, and so on. So about this, there should be going back to the clear guidance. And the second point is that there should be the clear guidance as to how business-to-business collective agreement, collective bargaining is analyzed. What I found is that this is the one work that I did with the Australian labor law professor Shayama Crystal. Australian competition law has the exemption system that exempt business-to-business collective bargaining. Although the Australian authority, Australian Competition and Consumer Commission, ACCC, are very careful in granting exemption, but it's certainly a great source to see how competitive effect can be examined in relation when it comes to the collective bargaining, B2B collective bargaining. And also it shows us that the great potential that the B2B collective bargaining enhances, improve the efficiency. So this is, unfortunately, this is only in Japanese. It's already published on the JFTC, Japan Fair Trade Commission's website. Just remark is that it doesn't mean that the JFTC has endorsed my view. It's just on JFTC. And for your information, you haven't missed any, you won't miss anything. ACCC has the very detailed guidance and it's very transparent. You can see every cases. So it's a big great source to see if you what I try to say. If you want to know further, this is the source of the information. The last thing is just the no. We are still there. So the last thing in relation to the like association and the cooperative or horizontal activities amongst the self-employed workers or gig workers, like cooperative system. Like there should be, well, actually, even if the self-employed workers do not have the access to the protection or do not have the right to associate or strike, they can, in theory, they can form the cooperatives, and actually the activities of corps are already exempted to a certain extent under the Japanese competition law. But however, the JFTC is actually nowadays challenging the corps, and it's testing time for the corp system. And I myself have not reached a clear conclusion as to what the corp should be allowed to do, and so forth. So there is an area that the JFTC or competition law scholars can re-examine. So that is one. So I just finished the first part, unionization and creating association, a horizontal solution to measure, to counter bargaining power issue. And secondly, just quickly, another role, this is another way to address the bargaining power issue. And also, what the competition authority can do is to regulate, that's a simple, to regulate the buyers or employers' abusive practices. Well, the competition law can be one of the legal rules that regulates buyers or employees' abusive practices. This is particularly relevant to Japanese competition law because it has the regulation of the, it regulates the abuse of super bargaining position. Thank you for listening.
Okay, that's perfect. Actually, I was going to ask you exactly about cooperatives because in Europe we have this new phenomenon of creating workers' cooperatives to, practically speaking, to replace trade unions for all those type of jobs where it's not clear whether you can unionize according to the law, especially freelancers, as we said before, gig workers, etc. I've seen examples and some interesting studies in Europe, in particular relating to Italy, France, and Belgium. Like, for example, in Italy, especially in the visual artists and a number of different workers, especially in the in that area, practice speaking unionizing in that way. So it was particularly interesting to see, also to have a look also at your view from the perspective of cooperatives, because this is what they are doing. Like, in Italy, it's called Doc Servizi, for example, one of these cooperatives, and is the biggest one. But that's what they're doing is, in fact, they are unionizing, because this is what, through that cooperative, what they are trying to do, to achieve that level of bargaining power that would allow them to negotiate contracts on a more even playing field. So that's exactly what. So they are trying to replace traditional trade unions. But in your very last, in the very last bit of your talk, you refer to superior bargaining power position under the competition law, abuse of superior bargaining power. Can you explain how is this enforced in relation to self-employed workers? And do you think that this is a good way to apply, an appropriate way to apply these laws? This obviously with respect to the Japanese regulation.
Yes, thank you. Well, yes. My answer is again wrong. So I first explain briefly what the regulation of superior bargaining position is, briefly, and then my answer to it, well, it is working. It is functioning to protect self-employed workers, but there are space for the improvement. That would be my answer. So if I go, yes, this is abuse of superior bargaining position. This is an image. So so the regulation is applied to any transaction where there is imbalance of bargaining power and not limited to, obviously, to the self-employed worker. And the situation in which the self-employed workers are involved. Typical practices, typically, the major recent 5 cases, all related to the large retailers and suppliers, but it's not limited to that either. Then the typical practices regulated under this include late payment, a retrospective reduction in price, and other retrospective changes to contract terms and conditions, forcing counterparties to offer a financial contribution or to dispatch employees, and so on. And these are deemed to be unlawful only when it's regarded unfair. So this is not per se prohibition. For example, requesting a reduction is not unlawful if the service does not meet the standards set under the contract. Then the Japan Fair Trade Commission also considers that it's necessary that the practice widely affects the way that business operates. And then the JFTC normally finds continuous abuse practices that harm dozens of counterparties. So it is very large retailers and dozens of suppliers. It's widely seen a phenomenon. Only in that case, the JFTC formally step in. Defining the relevant market and finding the dominant position, on the other hand, is not required to find a violation. That is the and also this is not the criminal offense. Although there have been several civil damage suits, the majority of cases are brought by the JFTC, as in every other competition law cases in Japan. There are also legislation that, such as the Subcontractor Act, that supplement the regulation. Have I? No, not there yet. Sorry for the wrong explanation, because when the JFTC finds the abuse, they may issue a cease and desist order, and when they do, they must also order the offender to pay fine, which is 1% of the total sales affected by the practices. So this is the formal procedure, but the JFTC often use the soft measure instead of in place of the order. The JFTC can also issue warnings and alerts, and also Japan introduced a commitment procedure last year, and it is expected that the JFTC would use that procedure, particularly to regulate, in order to regulate these practices. And furthermore, the JFTC regularly issue guidelines and reports and conduct sector inquiries and studies, like 1 or 2 studies every year, and clarify their position in this document. So it seems that So it seems that so this is I think this is important because it's very important to see not only the substantial aspect of this regulation, but also the procedural and how it's implemented in order to evaluate the effect, the impact of this regulation. We need to look at this soft measure and the studies and reports and the guidelines as well. Then, so it seems that these documents, all the JFTC documents are taken seriously by both practitioners and businesses. Then, finally, in relation to the self-employed workers, this is a very recent action taken by the JFTC. The JFTC, as their responses to COVID-19, they have published several requests to the relevant businesses who employ freelancers and sole traders. They stated that when they make the changes to the existing contracts, they should ensure that they negotiate with freelancers and sole traders on a good faith. This is one of the area that JFTC, one of the activities that JFTC is doing. And before this, the franchise guideline is a very important piece of the document, relevant to the kind of self-employed workers. And in this, the JFTC states that the franchisor must not mislead. They must not force the franchisee to buy unrelated goods and services, and they must not make them responsible for the losses that were not brought about by the franchise mistake, for instance. Then when it comes to the sector inquiry kind of reports, these are the reports that recently done by JFTC, including the TV contents production that is about freelancers, funeral services and bridal services, this like sole traders. So these are not do not focus on self-employed workers, but broadly explain what the practices in these sectors can be seen as problematic from the point of abuse of civil bargaining position regulation. Then let me state my views of, finally, state my views on the current state of regulation. I think I would make more proposal rather than criticizing it. For instance, as I said, JFTC thinks considered as the widely, although it's not required and by the law, JFTC tends to, when they bring the case, it's almost always big, large retailers that everyone would know the name of it. And then if they are no, they use this soft measure. These are influential to some extent, but in my opinion, they are too soft, I think. So there should be somewhere in the middle. The way I think I'm now happy with the substantial rules, and it's actually a good balance between the substance of the procedure, but there are some gray zones that's left out by the JFTC, but needs to be addressed, not with this fine, perhaps, more to do with it, more by the private litigation. So, yeah, but so a caveat is that this is only my personal opinion. Obviously, I think this is the area every Japanese antitrust scholar has slightly different opinion, even if they are they agree there should be some regulation in place, and the JFTC is actually in a good position to regulate this kind of behavior practices. So when we discuss this, we have to consider three issues, I think, like fundamentally or theoretically. in relation to with regard to the self-employed workers, working conditions and terms, first is whether or not the self-employed working workers' working conditions and terms should be regulated ever. And second issue is whether the competition authority should be in charge of regulating any abusive practices arising from the imbalance in the bargaining power. The third issue is whether or not the competition law and authority should get involved in protection of kind of workers or any kind of workers. My answer to the first and second question is obviously yes, but I think it will take 1 hour or 2 hours to explain it, so I'll skip it and moving on to the third question. I will focus if that is okay with you. Okay?
Absolutely.
Yeah, thank you. So, about third issue, yes, it's. I think I think that you would suspect that I think there is an agreement globally that the competition authority should intervene non-poaching agreement. Non-competes that major issue that we should look at. But on the other hand, when it comes to the vertical issue, the contract terms and working conditions and terms, our opinions may vary. Actually, in Japan too, there's a variety of opinions and there are several issues to be considered. Most obvious one would be the division of labor, how we allocate the tasks, whether it's labor law or the employment law or the competition law, which is better suited to deal with this problem. So employment law obviously may appear to provide a better solution to individual contractual term. One may think that we should leave that issue to them totally. In Japan, employment law has specific enforcement bodies called Labor Standards Office and Labor Standard Officers. A number of that officers is 3,000, while the JFTC has only 850 staff in total. The economy of scale or economy of scope would be greater for the labor law regulators or employment law regulators, for instance. It would be easier or be more cost effective to find the abusive practices both towards employees and self-employed workers in one go. So I might agree if one argues that the JFTC should concentrate on tackling typical competition programs. But having said, however, in case where other administrative organs, legislature, law courts, and trade unions are slow in responding to the problems arising out relating to the self-employed workers, the JFTC's intervention should be justified, and perhaps at least for a short period of time. In this regard, perhaps we should be mindful about the JFTC's gap-filling function or its function to quickly detect unmet problems, raising awareness amongst the citizens as well as the competent authorities and prompting them to respond. In Japan, the example is such example include the financial instrument or the fair rules, establishing fair rules in the financial market. The JFTC's case actually was very important. It's now a part of the Financial Instruments and Exchange Act, and also JFTC was functioning as a consumer protection authority, which is now a consumer agency. So I would like to expect from the JFTC's activity. This is what, if this is what, and this is happening, this happens from the out of JFTC activities in relation to the gig workers and self-employed workers, that would be great. Then, assuming that at least for the time being, the problems are to be dealt under the competition law, or more specifically under the regulation of a superior bargaining position. What I would like to see is measures to facilitate civil-driven enforcement, or like regulation prompted by private parties' initiative or actions. And to do this, in order to make it happen, there should be three measures. I think they are necessary. First of all, there should be greater protection of whistleblowers. Then, second thing is that if the JFTC amends the consultation system to allow the trade union association or group of workers to collectively ask hypothetical legal questions, and if they can obtain detailed answers from the JFTC, that would be helpful. As of now, it is impossible. They are not allowed to ask hypothetical questions. They have to be the one who do the employee practice. So I think it might maybe too much detail. And last thing is like easier for you to understand, I think. Like expanding the labor tribunal's jurisdiction to include disputes arising under the regulation of abuse of superior bargaining position, as well as the Subcontract Act. So I think what JFTC is doing so well, and I'm glad, particularly since we had these reports and following activities, what the development in this area is very promising, I think, but there are more things to do. Thank you.
No, thank you very much. It was lots of food for thought, and it made me think a lot also about bargaining positions and alternatives. As you said, there might be alternative institutions to the antitrust authority that also has limited capacity sometimes and limited resources. But not all of them are always viable solutions, let's say like that. For example, many people say, why don't we leave these to civil courts in many of the contractual issues that do not also relate to specifically to labor law, like for example for freelancers, right? Why don't we leave well, there is you kind of mentioned it, and at some point there is a problem that is very well known also in contract law called the fear factor, right? So if I'm locked in with you, it's very unlikely that I will sue you for breach of contract, for example. And this has been empirically proven countless times in many papers. So I totally agree with you. We need to find solutions that blur the line between administrative, where administrative powers and judicial and the power of the judiciary somehow either cooperate or even merge in order to somehow tackle these problems that otherwise, can be solved only on paper, but then in practice they always remain there. So do you think that then to what extent do you think that there should be some sort of institutional analysis that to allocate the power to decide each single case. So do you think that there should be somehow a general a law that allocates cases in advance, or do you think more in a sort of case-by-case institutional analysis, thanks to which we can then allocate each single case either to the labor courts or to the antitrust authority? And how do you think that this power should be allocated?
My I was criticized when I said it, but I still keep my position. Don't allocate them. Both of them should have. So,
okay. Yeah.
When it comes,
parallel powers. Okay.
Yeah, parallel. Until when we are sure that the competent authority, or like one institute, is dealing with the issue brilliantly well and not biased, and then until that time, it's always good to have the. I think we haven't reached that stage yet when it comes to the self-employed issue. I think the I don't know, it's might depend on the I don't know. What is happening in Japan? What? Sorry that this is recorded. I don't want them to listen, but that's okay. What we often see is that's like the Japanese people like politely like giving way to the other institute. Oh, this is not our issue. You do it. And the other authority says that this is not mine, you do it. So this is very often happening. So I think and also like subcontractor act, for example, or this abuse of supervisory position can be like civil issue as well. So it's good to have two layers. The lawyers, when they bring the case, they can have two different claims. One is civil, one is another. So that kind of thing. Now, I think that is good, and I don't see what I believe is that there is no single answer, like a universal answer, that should be applicable universally to the whole world should follow, because its institution is so different. Institution setting so different. So we need to look at really how all the institute works in each jurisdiction. And in the Japanese regulatory and judicial system, I think I don't see any reason to create the clear line dividing. What do you think?
Yeah, no, I from this point of view, I actually agree with you, and I kind of try to make this view also in some of my papers, but there are some differences, obviously, like when you said it, out of respect, Japanese institutions sometimes let other authorities, or anyway governmental authorities, to deal with the problem. In Europe, I see more a habit of passing the buck, so they just say, at least in Italy, usually authorities don't want to just deal with something, and so they will pass the buck to someone else, which is a more likely result of a similar situation. But from that point of view, yeah, I totally agree with you. I mean, there are no universal solutions because, for example, abuse of superior bargaining power, you mentioned it, and it's very often asked whether competition authorities should be given also the power of deciding on the basis of these of relational power, let's say, rather than structural power, which would be dominance, right? Well, that it depends. I totally agree with you. It depends. It depends on the design of the institutional design, but not only of the antitrust authority, but also of all the other public authorities that are there, including the judiciary. So it very much depends. So sometimes, in Europe, we are granting these new powers to antitrust authorities, sometimes without carefully looking at that. That doesn't mean that is for sure a mistake, but that, you are kind of tossing a coin and you are hoping for the best. While our competition authorities are not very often sure about how to use that tool, that new tool that they have been given, because they look at judges and they say, okay, they can do something similar. Why did you give me, this new power that is similar to what I'm confused, which is something that can happen if you don't match these new tools with the institutional design of these authorities, of all of them. So I totally agree with you. That it should always be a tailored approach, even more in developing countries where I'm working now. Very often, unfortunately, legal transplants of not only from the point of view of the substantive laws, but also of the institutional design takes place, so that they adopt, everything from, and then bit by bit they have to adapt the laws. This is what is happening, for example, here in Kazakhstan, where very often the competition laws change. The last reform, massive one, was enacted 2 years ago, and this could be one day I would like to ask you also about that. For tonight, I tortured you enough, but it would be very interesting to know, what do you think about some of the local competition laws that very much look like, for me, to more an abuse of superior bargaining power rather than an abuse of dominance, because they don't really require the finding of structural dominance, in the sense of competition law. And from this point of view, though, I was really curious while you were talking. Does it mean that in Japanese competition law, abuse of superior bargaining power entails a sort of presumption of existence of dominance, or that just it doesn't matter whether there is market dominance or not? So is it or it doesn't matter at all? Okay, so it's not a rebuttable presumption that the alleged dominant firm can rebut somehow. No, it just doesn't matter. They cannot use it as a defense. I'm not dominant.
No.
Okay. That's good.
It's the superior bargaining position.
Okay. So it's merely relational, and it remains relational. It doesn't imply a presumption of structural dominance, the relational dominance. Okay.
Yeah. The 90% of the textbook, there is some different view on this, but 90% of the textbook is clear about this. It's relational. The power is relational, no, the absolute. Okay,
wonderful. Thank you very much. And it was really wonderful. We touched upon so many topics. It was incredibly stimulating. It was incredibly engaging talking to you tonight. And I hope to be able to do that soon again. And in the meantime, wish you a good night. And I hope to see you soon.
Yes, thank you. Thank you for having me. And thank you very much for your patience.
It was great having you.
Thank you very much.
See you then. Bye-bye.
You too. Yeah.